Good morning, all. My name is Evan Barnes. I'm founder and CIO of Traction Financial Partners, and with me is Akshay Pradhan, managing partner at Pradhan and Backus. And we're excited today to walk you through our legacy blueprint and talking about estate planning. I'm going to give Akshay a second here to introduce himself, and then we will share our screen and jump into the webinar.
Good morning. My name is Akshay Pradhan. As Evan stated, I'm with Pradhan and Backus Law Firm. We practice a number of areas, a large part of which is estate planning and tax strategies. I've been involved with a number of large private law firms as well as the Fortune 500 corporations. But ultimately, we always get back to my favorite area, which is estate planning. Looking forward to this.
Awesome. Great. Thank you. Let me share my screen. All right. I believe we are up and running. As we go through here, please feel free to type in any questions into the Q&A. On your screen, we'll get to the questions at the end of the presentation. But as we're going along here, and if something pops up, make sure you type something in there, and we'll address those as we wrap up the webinar today. But again, we're going to be talking about the legacy blueprint, maximizing wealth transfer through a strategic estate planning. The agenda for today, Akshay will go through what is estate planning, key components of an estate plan, the importance of a will, understanding trusts, power of attorney, health directives, minimizing taxes, regularly updating estate plan, and some common mistakes. He will then pass it off to me, who will go through tax efficient planning ideas to transfer wealth, which will include inheriting qualified retirement accounts, Roth conversions, leaving tax unfriendly assets to charity. We'll discuss step up in basis, and end with maximizing gifting, which we'll talk about the annual and lifetime gifting limits and the sunset of the federal estate tax exemption. But I'm going to turn it over to Akshay here and let him take it and get us going.
Excellent. So most of us, if not all of us, are familiar with the terminology estate planning. Sometimes we think of estate planning as being focused only after death. Estate planning actually can be structured so that it's beneficial prior to your passing as well. Mainly, estate planning has to do with how you manage your assets. During your life, if you're going to put it into a trust, which we'll talk about in a bit, so then we can look at the benefits during your lifetime, as well as supplemental estate documents that provide certain powers while you're living. So it's a number of asset and decision management tools, both before and after pass. We focus on a number of goals. Three of the primary goals that cover most estate plans have to do with how your wishes are going to be honored. Sometimes if we don't have a proper estate plan in place, we have to resort to how the state would then treat our estate, which is not necessarily what we actually wanted. So drafting a correct estate plan will honor our wishes. It'll also allow us to minimize potential taxes based on your circumstances, and as well as legal fees. Proper planning ahead of time will not require a lot of legal work later in trying to interpret what you wanted to have been done. And then also, how are we going to provide for our loved ones after we pass? There are many, many components to an estate plan. However, for the purposes of this webinar, we'll focus on 5 major areas. The first, you have the basic will, you have trusts, then you have 2 powers of attorney. So you're talking general, and then also on the medical side. as well as healthcare directives. So very, very high level, and we will get into the detail of each of these. But a will is a set of instructions that describe how you want your assets distributed. A trust takes it to the next level where we talk about in greater detail of how the assets shall be managed both prior to and after you pass away. It also instructs the trustee to know what they can do with those assets, depending on the trust, if you can put assets in or take them out. And they also provide various levels of protection. Powers of attorney, typically we talk about the general power of attorney, then we have a healthcare power of attorney. Both are providing the legal authority for somebody other than yourself to act on your behalf. And then finally, healthcare directives basically instruct certain individuals, such as physicians, as far as what needs to be done in the event that you can't express that. So in the event you're incapacitated, and whether that be mentally or physically. A will is the most common estate document, or at least the document most individuals are familiar with. Although I will typically advise clients, and it'll be based on your circumstances, but typically go the route of a trust. Will is in fact a critical component. And even if we do go down the road of a trust, there is a form of a will that we would still be required to draft. But to begin with, the first step is to have a will. A will, if it's properly drafted, clearly states exactly who those individuals are that you wish to distribute your estate to, your assets. And so we want to very clearly designate the beneficiaries, as they're called. In the event you have minor children, then you also take the opportunity in a will to explain who shall serve as the guardian for your minor children. If properly drafted, again, the will is going to very clearly describe how and what assets should be distributed, and then, obviously to whom. This is the drafting of a will covering these areas is very, very critical, because if it's not clear, then it's subject to the interpretation of another, whether that be in the court with the judge or another entity, the executor, on how it needs to be distributed. And so the more clarity offered in a will, the more likely your wishes will be followed. If you don't have a will, then we do get to that scenario where we have to hope that the state is in fact distributing our assets the way we wish. And very unlikely will that be the case. Now, the state's not going to distribute necessarily against what we would have wanted, but not ideally in line with what we wanted. It also can result in family disputes to say, hey, no, mom wanted us to distribute it this way. I had a conversation with her. Oh, no, I had a different conversation. And so you don't want to end up in that route, whereas in a will, you can make very clearly, this is, in fact, what I wanted. And so then you reduce the chances of family disputes. Trusts take it to the next more complicated level. And if drafted correctly, it is a very strong defense tool against many areas, including, and depending on the type of trust, creditors. It provides great detail on the management of your assets. There are a number of trusts, some of which Evan will address later on, and when he presents, very high level. We get into the category of whether or not the trust is revocable or irrevocable. As the name suggests, revocable trusts allow for greater flexibility in that you can literally revoke the trust. You can create the trust and later you can revoke it. You can place assets into the trust, or you can take assets out of the trust. And it just depends on your, the particular life circumstances at that moment. An irrevocable trust is just the opposite. Once it's drafted and executed, that's it. You have no more say as to what goes on in that trust. So you think, well, why would you have an irrevocable trust? Well, an irrevocable trust provides other benefits, such as additional protection against creditors. It also goes towards in different agencies qualifying your assets as out of your estate. Whereas if those assets are in a revocable trust, they may be considered as part of your estate. And so that's where we have both benefits for either the revocable or the irrevocable. The biggest, most common preference from individuals is that the need to avoid probate. Probate has to do with the probate court, and once you pass, how are your assets distributed? Hey, anything in your estate has to go through probate court, which can be a very long and arduous, expensive process. So with the trust, it's private. You do not need to go to court with the trust. And so all the trustee does, who is the designated individual to handle the trust, is to say, okay, this is what the trust says. It's a set of instructions. No need to go to a judge to get this taken care of. It's also a private document. It's not published. Nobody will know about these. And then it's less likely that there's any individuals that are contesting what those terms really are. It also manages the assets for the beneficiaries very clearly. So then the beneficiaries and other individuals don't have to make the determinations or the decisions on their own. When you have a trust, when we say it replaces a will, it does so in a way. You still need a will, but the idea is to transfer your entire estate into the trust. For anything that is not transferred to the trust, you have a catch-all, which is a pour-over will, not a regular will, a pour-over will. And what that means is that says, hey, anything still in my estate pours over into my trust. That single instruction, though it has to go through probate, cuts all the nonsense out of the probate process. It's one instruction. Okay, here it says my estate goes to my trust, done. And now you go to the trust instructions. Powers of attorneys. There are two general powers of attorneys, one of which is called a general power of attorney. And then there is a healthcare power of attorney, which we'll talk about here in the next slide. A general power of attorney typically addresses financial business aspects of your life, granting that authority to someone else to take care of those decisions. A durable power of attorney is kind of a tweak on powers of attorney, where it says, hey, in the event that I become incapacitated, we're going to keep this power of attorney active and continue to provide those powers. A limited power of attorney is just that. A limited power of attorney will limit the amount of powers that an individual may have over the document and what they can do on your behalf, and could be limited by time as well. The other power of attorney is known as a healthcare power of attorney, or sometimes a medical power of attorney. And as its name suggests, this has to do with making healthcare decisions, as opposed to a general power of attorney, which is more on the finance business side. There is another document that's known as a living will. Sometimes people get confused because a living will sounds like a will or a pour-over will. But a living will is more focused on the time you are living. And that's why it's called a living will, for amongst other reasons. A living will talks about how you would want medical treatment in the event that you can't express it at that time. So let's say that you are in a vegetative state and you can't express your decisions, your preferences, how you want your healthcare healthcare decisions to take place. Well, the living will instruct individuals, such as your physicians, as far as how you need to be taken care of. So let's say, hey, if there's two different physicians, if I'm in a vegetative state, as an example, and I am on life-sustaining equipment, well, after 7 days or 10 days, if they have determined that I will not come out of this vegetative state, well, then go ahead and let me go. Take me off this equipment. And that is, that's the instruction. It's done with. It can be difficult for family members to make that decision for you without a living will. There may be some family members that say, hey, let's keep them on. Let's see how long, maybe they'll come out of it. Someone else will say, hey, no, mom said she doesn't want to be artificially, kept alive. So there's a lot of potential for disputes there. And a living will makes it very clear as to your decisions. We don't have to then rely on, conversations we may or may not have had. Another key component to drafting an estate plan has to do with tax planning. Now, the extent of tax planning will depend on your particular circumstances, the size of your estate, for example. And so there are certain, tax thresholds, which Evan will talk about, lifetime gift tax exclusions, your annual exclusions. But in any event, for either of those or other taxes, we can structure your estate plan so that we can minimize those federal and estate taxes. Sometimes, a state may have certain taxes that another state may not. And so it's important to also be familiar with your particular state's taxes. Some strategies include gifting assets. So you're over time removing assets from your estate. Again, the benefit there is that anything in your estate goes through probate. So reducing your estate is a benefit as far as taxes go and for other reasons as well. So gifting assets, establishing trusts, like we talked about. Let's move those assets out of our estate into a trust. And that too is a way to reduce your taxable estate. It reduces the taxes that would be then applied to your estate. We also have charitable donations. So, different from gifting to your child, we're talking about charitable donations and, who that can go to using certain trusts that are focused on charitable donations. And again, we are reducing the size of your estate that could be subject to taxes. Once drafted, it can be an intimidating process. However, if you talk to a financial planner or an attorney, they make this whole estate planning process a lot more simple. And actually, it's good. It provides comfort. It reduces stress because then you know how your estate is being taken care of, and it answers a lot of your questions. However, you're not done upon drafting the estate plan, signing it in front of a notary and witnesses. That's not it. You do have to regularly update your estate plan. Many times we have kind of put a 3-year recommendation. Hey, every 3 years, let's review your estate plan. But we feel more comfortable doing this annually. It can be simply, hey, let's have a 15-minute conversation annually. Let's see if any changes need to take place, because laws do change over time, especially tax laws. So we will, reach out to you and say, hey, new changes here to the law, let's discuss. But in any event, we should always work together, whether it be your financial planner or an attorney or an accountant or whatnot, but somebody familiar with estate planning to talk about it annually. Major life events such as marriages, divorces, or the birth of a new baby. All of these events can impact your estate plan. So, even if it hasn't been a year, if you have a new baby or if you get married, let's talk. Things can definitely change. And also just your financial situation, right? If you get into a divorce, sometimes you're cutting 50%, right, of your financial situation, your finances, then your financial situation has changed. Or perhaps you won the lottery. Hopefully that's the case, in which case you now have, $250 million more in your account. Well, how do we address that? So there's a number of reasons to keep your estate plan updated. Not doing so can cause a lot of problems, potential problems, I should say, whether it be a tax issue or granting assets to an individual that you no longer wanted to benefit. And so make sure you regularly update your estate plan. Simply not having a will or a trust can be an issue, because why? It then goes to the state to make that decision. Do you want the state to determine how your assets are to be distributed, right? The state just says, hey, we set an order of who the assets go to. We don't know if that's what they wanted, but there has to be a standard. And the state's not trying to do anything ill intended, but they have to follow a certain process, which very well may not be in your best interest. And so it's a major pitfall to not have an estate plan in place. And then also just drafting something, a template from the internet, right? Hey, there's a will here for $50. Let's fill this out. Well, you're not considering tax implications, which can be extremely expensive. This, depending on your estate, you're talking hundreds of thousands of dollars. So consider doing this properly with a trained professional. And then, thinking that you're Superman or Superwoman, that you won't become incapacitated during your life. We just don't know what will happen. And so do not neglect to plan for a potential incapacitation. And so you're talking powers of attorney, for example. So make sure you take care of the different aspects of estate planning like we talked about here. I will pass this on to Evan. Thank you so much.
Thank you, Akshay. That was great and laid the groundwork for a couple of financial planning ideas and topics that I wanted to cover. And so leaving a legacy is obviously important, and something that we walk our clients through, and how to best do it from a tax perspective is something that we wanted to cover here for a few minutes. And for the most part, outside of your house and maybe some other personal assets, retirement accounts tend to be some of our biggest assets. And when those pass on, how is it treated from a tax perspective to those heirs in the way of inheriting retirement accounts is something that we're going to talk about here. So whether it's a qualified retirement account, looking at a 401k, IRA, SEP IRA, simple, there's lots of different retirement plans available out there. And talking in particular to the pre-tax retirement plans. And so when we inherit one of these plans, and I'm talking specifically for a non-spouse inherited IRA. Okay, so if your spouse passes and you inherit their 401k or IRA, it's a little cleaner. You can roll it into your own retirement account. You can keep it in their name. It kind of depends on your personal situation, tax situation, age, that type of stuff. But I'm talking more specifically if you wanted to pass it on, for example, to your kids. So an inherited IRA, the beneficiary in this situation cannot make additional contributions. You generally, though, can withdraw money right away without penalty. Okay, so most of you may be familiar with, if I have a retirement account, you don't want to take withdrawals from the retirement account prior to age 59 and a half, because you're usually hit with a 10% penalty from the IRS. If you get an inherited IRA, you can generally withdraw right away without that 10% penalty. Something that is constantly changing depending on the administration and what Congress is doing is, when you inherit an IRA, typically you have a certain period of time to distribute or take out or liquidate that account. Hey, it used to be, hey, you can stretch it out over your lifetime, and they've changed rules from time to time. Currently, you have until the end of the 10th year following the death of the owner. Okay, we're going to talk about why that could be a tax bomb for beneficiaries and may not be ideal. depending on your situation and their situation, but you only have 10 years to distribute the inherited IRA. Most of the time, not all the time, but most of the time, we will recommend that you distribute the inherited IRA equally over those 10 years. It tends to spread out the tax liability. But again, you don't have to do it that way. But that's the most common approach is, okay, we're going to spread out the inherited IRA over 10 years. If you inherit $1 million IRA, we'll take out $100,000 per year plus a little growth. And by the end of the 10th year following the death of the owner, that IRA needs to be liquidated. Withdrawals are taxed as ordinary income. So again, from a planning perspective and leaving a legacy, not that your kids are necessarily going to turn down inheriting a large IRA, but from a inheritance perspective, a lot of times they're inheriting these IRAs when they're in their 50s or 60s, right? And so that could be their prime earning years. So if you inherit $1 million IRA and you take out $100,000 every year for the next 10 years, that could significantly impact that heir when it comes to taxes. So we're going to talk about some strategies here on the next few slides. One of the most common strategies that we use with folks is a Roth conversion. Okay, so what that means is, and just quickly, from a tax standpoint, an IRA is funded with pre-tax dollars. Okay, it's either a rollover from an old 401k that you were contributing to that was reducing your taxable income, or if it's a traditional IRA that you get a tax deduction for contributing to. An IRA is funded with pre-tax dollars. It grows on a tax-deferred basis. So you don't see taxes anywhere on the IRA when you contribute or as it grows, but when you take the money out, like I said in the last slide, you are taxed on that distribution as ordinary income. A Roth IRA is the exact opposite. So a Roth IRA is funded with after-tax dollars. You don't get a tax break when you're putting money into a Roth. It also grows tax-deferred, but the distributions on a Roth IRA are tax-free. Okay, so again, just the opposite of what you're seeing when it comes to the IRA side of things. Okay, the amount that you convert, so a planning idea is, all right, typically when you retire, your income, your ordinary income or effective tax rate drops in retirement. And we're going to show you an example here in a second. But during those times early in retirement, we could convert money from an IRA to a Roth. That is a taxable event. It's ordinary income in the year that you do the conversion. But the idea is hopefully you're doing it at a low tax bracket. Okay. The benefits of doing so, like I just said, you can convert at a lower tax rate. The other part of it is you help reduce required minimum distributions that you are forced to take out currently at age 73 or up to age 75, depends on when you're born. And that's something else that they're constantly changing when the required distributions from pre-tax retirement accounts need to start. But at a certain age, currently, let's say 73, you are required to take distributions from your IRA. Okay, at that point, you possibly maybe you need that. Maybe you need that to supplement income or retirement. There are plenty of folks who do not. And so they're required to take taxable distributions from a retirement account that they may not want. So if we can convert monies from IRAs to Roths early on in retirement, that will reduce what you're required to take out once you get to the RMD age. You do not have to take RMDs from Roths. Okay. The other part is when a Roth IRA is inherited, has the same rules in terms of you have to distribute the account within 10 years of the year following the death of the owner. But those, again, the distributions are tax-free. So in that scenario, we can have some fun and decide, all right, maybe we want to delay when we take out the Roth IRA account and distribute that a few years, or maybe the whole 10-year, you just let it grow because it's going to be tax-free when you have to take it out. There's a lot more flexibility when you inherit a Roth IRA as opposed to a traditional IRA from a planning perspective. Something else that's really helpful if you can get as much money from an IRA to a Roth. This isn't necessarily an inheritance issue per se, but it could be because you can use the Roth funds towards long-term care needs. If you go into a situation where you are in a nursing home or assisted living or whatnot, having additional assets that are tax-free to distribute when you have to pay for those types of cares could help save assets that are going to be passed on to the next generation. Okay, so again, another benefit of using this. Also, reducing income in retirement, the last bullet point there when it comes to Medicare premiums, when you have to take required distributions from the IRAs and pay taxes on it, that could bump you into brackets you don't want to be in when it comes to how much you owe in terms of Medicare premiums. Your subsidy could be reduced and you may owe higher Medicare premiums going forward. Roth IRAs help that out quite a bit. So for example, we took this, our planning software, just as an example, had a client who retired at age 66. And you can see on the far right-hand side, effective tax rate of 0. Okay, under the total or the gross total income, they're making $85,000 in 2024, $88,000 in 2025. That's off of investment income. It could be Social Security, that type of stuff. But because they're in a tax bracket where they really don't come out, whether it's from standard deductions or if they itemize, whatever the personal situation might be, their effective tax rate is basically 0. That's a perfect time to do those Roth conversions. We can convert a lot of money from IRAs to Roth IRAs during those years when we have a low effective tax rate. And you can see in 2031, at age 73, the gross total income pops up to 161,000. That's because the required distributions kick in that year. Okay, so our effective tax rate on the far right-hand side in year 2031, still low, it's 11%, but you can see it creep up from there because we're taking distributions from the IRA and that's taxable. Okay, so again, if we can use those early years in retirement to convert from IRAs to Roths, that should reduce our income tax liability throughout retirement and also build our assets, as you can see here on this slide. Okay, so 2024 through 2030, what this is showing is you can see that the taxable portion of Roth conversions, we are paying extra in those years early on in retirement by converting IRA money to Roth IRA. So we're still hanging out in a decent tax bracket during those years. But if you look at the bottom of the screen, in the middle, you can see cumulative taxes. So this particular client, throughout the rest of their plan, $485,000 worth of taxes is what they're going to owe. Right below that, you can see an arrow pointing down. By doing Roth conversions, we saved them $128,000, almost $129,000 taxes. Okay, that's because we're paying taxes early on in retirement at a lower tax rate and saving on taxes in the future by not having to take as much out in terms of requirement of distributions when we don't need to take those distributions. And on the bottom right-hand corner, total portfolio assets for this particular client at the end of the plan, 5.3 million. You can see in the bottom right that by doing Roth conversions, we increased their portfolio assets by 1.374 million. That's obviously very beneficial just from a planning perspective, but also from an inheritance standpoint. The biggest portion of that growth would have been in a Roth. So someone who inherited those portfolio assets, a good chunk of that's going to be in a Roth IRA, which is going to be tax-free. And also, like we talked about before, if we needed to use assets towards long-term care in the future, we have additional assets that will be able to access from a tax-free perspective, which means we don't have to sell the house. We don't have to use other assets maybe to cover that care that could be passed on to our heirs. All right, so an example or a conversation around tax unfriendly assets. Akshay had mentioned about giving to charity. Okay, so if we have a client who is charitably inclined, there are certain assets that should be used to go towards charity if we're thinking about how is the best way to pass on a legacy to our heirs as well. So if we put out here donating the second bullet point down, donating IRAs and non-qualified annuities upon death. We just discussed how an IRA, when distributions are taken out or taxable or inherited, you have 10 years to take the whole thing out and pay tax on it. The non-qualified annuity part of this is also not necessarily tax friendly because when it's inherited, you don't get a step up in basis, which we'll talk about in a second. And also the gains are taxed first when they get distributed. Okay, so if we can donate IRAs and non-qualified annuities to charity, that could be ideal because neither you or your heirs nor your estate will pay income taxes on the distribution of those assets. Your estate will need to include the value of the asset as part of the gross estate, but you receive a tax deduction for the charitable contribution, which can be used to offset or eliminate estate taxes. So if I identify a charity as a beneficiary of my IRA, it's still a part of my estate, it has to be included in the gross estate, but I get a tax deduction for the contribution over to a charity. Charities, because they don't pay income tax, the full amount of your retirement account will directly benefit the charity of your choice. It's possible to divide your retirement assets between charities and your heirs, so it doesn't have to be all or nothing. And again, you have the opportunity to support a cause you care about as part of your legacy. So giving to charity is in my opinion always a great thing, but if we can do it in a tax efficient way for everybody, that's a win-win. We talked about cost basis before and what a step up in basis is. So again, if we're thinking about passing on assets to the next generation, what are some tax efficient accounts or assets to inherit? We'll talk about which assets get a step up in basis on the next slide. But what is cost basis? All assets have cost basis, which is more or less its purchase price, what you bought it for. When an asset is sold, the difference between what you bought it for or the cost basis and the sale price is a capital gain. If it went up, if it went down, it's a capital loss. If it's a capital gain, you're subject to paying taxes on those capital gains. It depends on what tax bracket you're in and what your income looks like. That can affect how much you pay in taxes on those gains. But if there is a gain, you're going to be subject to taxes. Okay, so a step up in basis, what is that? When an asset's inherited, okay, rather than sold or gifted, the cost basis typically gets stepped up to the fair market value of the property at the date of the individual's death. From a tax standpoint, it's as if the asset was purchased at the price the investor received and is not taxed no taxes owed on any previous gain or loss. And I'll give you an example here in a second. A step up in basis is basically the date of the death of the owner. That becomes a new cost basis as opposed to what they originally bought it for. Okay, so what assets get a step up in basis? At the top here, the real estate does, individual stocks or bonds, mutual funds, art and furnishings, collectibles, some business interests. Now that we talked earlier, or Akshay did about irrevocable trust, so that kind of throws a wrench into this. So assets such as the above passing to an heir from an irrevocable trust may not be eligible for a step up in cost basis. But in general, when the assets are in the estate, you're going to get a step up in basis on those that I just listed. There are assets that do not receive a step up in basis when they pass to the beneficiary. That would include bank accounts, cash, CDs, IRAs, or excuse me, 401ks and other employer-sponsored retirement plans, IRAs, pensions, annuities. We discussed how a non-qualified annuity does not get a step up in basis on a couple slides ago when we are talking about giving the charities. So those are the the assets or accounts that do not get a step up. So if we were thinking what assets are best to inherit, the ones that do get a step up would be the ones we want to focus on. Here's an example. Susan purchased a home in 1980 for $75,000 and passed away in 2020. Okay, for those 40 years, the value of the home, let's say, increased to $500,000. In her will, she left the home to her daughter, Claire. Okay, so Claire inherited the home, and the cost basis was adjusted to the fair market value of the home on the day her mom died. Okay, so if you remember, Susan, the mother, bought it for $75,000 in 1980. In 2020, it's worth $500,000, and that's when she passed. That is the new cost basis. That's a step up for Claire. Let's say 2 years later, Claire sold the home for $525,000. So her gain is the $25,000, the difference between 525 and 500. Without the step up in cost basis, Claire would have inherited the home, and her basis would have been $75,000. And when she sold it for $525,000 in 2022, it would have been a $450,000 gain. Okay, so her basis, instead of being 500,000, was 75,000. And the last bullet point down there, if that was the scenario, and let's say that the federal capital gains tax rate's 15%, depending on what state you live in, but let's say it's 5, so 20% taxes in total. Okay. If we talk about, let's say she has an annual income of $50,000. If you make over a certain amount, then you have additional taxes, a surtax that's included. But let's just say that she's in the 20% tax bracket with between federal and state. Claire would have owed $90,000 in capital gains taxes if she didn't get a step up. So she would have made $450,000 at 20%. She would have owed 90 grand. But instead, because she got a step up in basis, she only owes $5,000 because her gain was only $25,000. Okay, so she saved $85,000 in taxes because of the step up in basis rules. Okay, so again, considering which assets are best to pass on to the next generation, assets that get a step up in basis are definitely on that list. Okay, when we're talking about gifting, currently in 2024, the federal gift tax exemption is $18,000 per person. This tends to go up every year. Okay, and when I say $18,000 per person, so if I'm married, we each are able to give $18,000, right? So $36,000 that we can give to qualified individuals, so that you can do a lot of gifting in 2024. If you do more than that, then you'll have to file a gift tax return. Okay, but currently it's 18,000. Something that Akshay mentioned before was the lifetime estate and gift tax. Okay, currently it's a pretty big number, right? So the lifetime estate and gift tax exemption in 2024 is 13.61 million per individual. So if you're married, that's 27.22 million for a married couple. Okay, something to consider as we get into 2025 is that the Tax Cuts and Jobs Act that was passed in 2017 is set to expire at the end of 2025, unless Congress acts and extends it or makes it permanent. Okay, so obviously what happens with the election later on this year will probably impact whether or not this gets extended or not. But if no action is taken, the exemption amount will revert back to the pre-Tax Cuts and Jobs Act's level, which was 5.6 million per individual. Okay, currently it's 13.61. So dropping from 13.61 to 5.6, that brings a lot more folks back into, hey, we potentially could owe, our heirs could potentially owe estate taxes upon our passing. Okay, that 5.6 is going to be adjusted for inflation since 2017, so it could end up in the $6 to $7 million range. We don't know exactly what it's going to be, but again, that's about half of what it is now. So those folks who currently are in good shape, or if they pass, they may not have a taxable estate. A lot more people are going to be brought back into that if the tax cuts aren't extended or made permanent. And so when we talk about types of trust that could be out of your state, like Akshay mentioned before, some of those irrevocable trusts, those are things that come back into play when you have a lower lifetime estate. Okay, other ways of giving that we can do while we're alive to help reduce our estate. Giving appreciated securities rather than giving cash for significant charitable gifts. Think about maybe giving appreciated securities. If I bought Apple and I have a huge gain in my Apple stock, and I want to do some gifting to charities, consider gifting some of your appreciated securities, because that's going to help save you on capital gains taxes. Okay, giving appreciated securities allows for avoidance of capital gains taxes on the growth of that security. Something else to keep in mind, we talked about IRAs before, a kind of a cool benefit. The second one down, the qualified charitable contribution or distributions, excuse me, QDCs. Upon reaching age 70 and a half, charitable gifts can be made directly from your IRA to a qualified charity. Okay, so that's not a taxable distribution. When you take money out of an IRA, typically it's taxable. Doing a QCD is a non-taxable distribution. The limit's pretty big. A taxpayer can make up to $105,000 per year in QCDs. Yeah, so that's one way. Again, if you don't need the distributions from your IRAs and you're charitably inclined, that's one way to do it in a tax favorable status. Finally, at the bottom here, donor advised funds. Donor advised fund is a private third-party administered fund created to manage charitable donations on behalf of an individual, families, or organizations. Yeah. So what you could do is you create a donor advised fund that you contribute to that you can use for charitable contributions throughout your life. Within the charitable contribution limits, 100% of the donations made to a donor advised fund are tax deductible, as if it had been made directly to the charitable organization. Okay, if you can, like we just talked about, donate appreciated securities into a donor advised fund. Okay, so if you're thinking, hey, I want to put $100,000 towards my charitable contributions in the future, and you can do it with appreciated stock, again, that's going to save you on potential capital gains taxes in the future if you would have just sold those. Funds with a DAF are invested, they grow tax deferred, and so from a ability to manage money, again, it's very tax efficient. And this is one way that we think that is very flexible in terms of how you can give to charities. Hey, you put in a donor advised fund that, and you, as long as they're qualified 501c3, you can use the donor advised funds to donate to charity. Just a couple of ideas of how we can help our clients when it comes to giving. Not going to jump into these. This is where Akshay would come in with some expertise, but these are really cool ways of accomplishing your goals of passing on legacy, reducing taxes, those types of things. Other unique types of trust, so a charitable remainder trust, CRT being one of those. Irrevocable life insurance trusts. We didn't talk much about life insurance today, but life insurance is one of the best ways to leave a legacy, to replace assets that you may have gifted, like an IRA. If you gifted that directly to a charity, to replace that with life insurance could be another approach, and life insurance proceeds are generally tax-free. But irrevocable life insurance trusts typically set up to help pay for estate taxes. And if we see the estate tax exemption drop and more people may be subject to paying estate taxes, or irrevocable life insurance trusts becoming popular. Intentionally defective grantor trusts, AB trusts when it comes to estate planning, and the qualified terminable interest property trust down there at the bottom is a great way when it comes to real estate and how to build trust around that. So these are things or concepts, ideas that we use in planning that Akshay helps set up. And they can be very valuable when it comes to leaving a legacy. Something else to consider, just to kind of wrap up here, is the use of corporate trustees. So one thing that Akshay had mentioned before is when you set up a trust, you have a trustee. But when the trustee is typically the grantor of the trust, but when that person passes, who's going to serve as the trustee for the heirs, if they're kids, to make sure that the trust is honored and distributed in the way that it was set up? You can use a corporate trustee to help make this happen. Having it professionally managed on behalf of the client's beneficiaries to ensure the terms are followed. It could help avoid family conflict, right? Which can result if a family member is designated as a trustee and kind of seen in charge of distributing monies. If there's siblings and one sibling is the trustee and the other one's like, hey, give me my money and those types of things. It can avoid that by having someone professionally do it. Our custodian is LPL. LPL has the private trust company that we use as the corporate trustee for trust accounts that we manage. So that's an example of a company that we personally use for trust accounts, that they could be the professionally managed corporate trustee. That wraps it up. Let's see how we're doing on time. I think pretty well. Have a couple minutes here before we sign off. Let me see if currently there's no open questions in the Q&A. Nothing in the chat. If there's any questions, we'll just pause here for a minute. And we can answer those for you if you have any. If not, we'll let you get to the rest of your day. But we appreciate everybody joining today, and we're excited to share this. It's super important. I know from a financial planning perspective and how we work with our clients, we can't set up the wills or the trust or any of those types of things, but it's an important piece of the planning process, and that's why we work with folks like Akshay to make sure that people are passing on their legacy in the way that they want. But that's it for us today. Again, we'll wait maybe a couple more seconds here, but I don't see any questions coming in. All right. Have a great rest of your day. Please follow up with any questions you may have. But that's it. That's it for us. Thanks so much.